welcome back. The U.S. Supreme Court begins its new fall term tomorrow with some of our country's most divisive issues, including the future of abortion, gun rights, and even religion, all on the docket.
Abortion, guns, the death penalty, and more are on the new docket as the new Supreme Court term gets underway.
My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. So the fall 2021 term of the Supreme Court has a chance to change the law dramatically. Now, here are some of the cases that are going to change our way of life. First, we go to the state of Mississippi in the case Dobbs v. Jackson Women's Health Organization. Who are the parties? Well, Thomas E. Dobbs, the state health officer of the Mississippi Department of Health, pictured here, versus the Jackson Women's Health Clinic. Now, the Jackson Women's Health Clinic is the last abortion clinic in the state of Mississippi.
They call it the Pink House. In this colorful building sits the Jackson Women's Health Organization, the last operating abortion clinic in Mississippi. Pro-life protesters gather out front regularly to try to convince patients to change their minds.
Now that you know who the parties are, here are the facts.
It's likely to be the most important term for abortion rights in at least 3 decades. The court will take up a Mississippi law that would ban virtually all abortions after 15 weeks of pregnancy.
After the point where the unborn child can feel pain, we ought to provide them an extra level of protection from the abortion.
But the Supreme Court has consistently ruled, beginning with Roe v. Wade, that states cannot ban abortion before around 24 weeks. Mississippi urges the court to take a bold step and overturn Roe.
If Roe is reversed, probably almost half the states in the United States would strictly limit abortion and perhaps ban it altogether.
So this brings us to the question presented. Now, the question presented is a question that can be answered either yes or no, that the court's going to address, and then explain how the relevant law applies to the key facts in this case. The question presented in this case are whether prohibitions on elective abortions before viability is unconstitutional. Now, the Supreme Court is going to hear oral arguments on this issue on December 1st, 2021. So let's talk about predictions. My prediction for this outcome is unsure, at the least. This case is an attack on Roe versus Wade and its subsequent case, Planned Parenthood v. Casey. Now, these are the court's precedents in the sphere of abortion. Now, the law currently doesn't allow any state to ban elective abortions before the 22nd or 26th week of pregnancy. This time is known as pre-viability. In this case, Mississippi has banned abortions after 15 weeks. So because of Roe v. Wade and Planned Parenthood v. Casey, this law essentially attacks the holding of those two cases. So this leaves us with 3 possible outcomes. First, they can just overturn the precedent, allowing each state to determine the legality of abortion at the state level. Second, they can uphold the precedent of Roe v. Wade, declaring the Mississippi law to be unconstitutional under current law. Last but not least, they can actually do a little bit of both. They could uphold the 15-week ban by moving the 24-week pre-viability mark back to 15 weeks. How do I think they're going to vote? Well, think about this. You got 3 liberal justices who are definitely going to vote to uphold Roe v. Wade. Then you're going to have a chief justice who I think is going to vote with the liberal justices based on stare decisis. That's the principle that obligates courts to follow its historical rulings, so there's some stability in the law. On the other side, I think Justice Alito and Justice Thomas are strong no's. They've been wanting to overturn Roe for a long time. The 3 wild cards are obviously the Trump judges. Now, I'm assuming that they may want to chip away at Roe by moving the 24-week viability mark to maybe 15 weeks as a first step in chipping away at the precedent. They could also be in the mindset of just overturning Roe and Planned Parenthood altogether and establishing the state's ability to regulate abortions in the manner that they choose. So my final tally for this case, I believe it's going to be a 5-4 decision. I believe the 5 conservative justices will either overturn Roe or make some modification to it, allowing this law to be upheld. But what do you think? Take the poll on the community tab and let me know how you would vote in this particular case. based on these facts. Now, from the state of Mississippi to the Empire State of New York, we have a Second Amendment case on the docket. Now, as restrictive as southern states are when it comes to abortion, that's how restrictive northern states are when it comes to the Second Amendment. The parties in this case are the New York State Rifle and Pistol Association of New York versus Keith Corlett. He is the superintendent of the New York State Police Department. Now, here are the facts for this case.
Yeah, Kate, this is a case out of New York, and it involves New York's law that strictly limits who can carry guns in public. It requires anyone applying for a license to carry those concealed weapons in public to actually show what they call an actual or articulable need to carry the guns. And in fact, several other states actually have similar laws here. But the two men who actually brought this lawsuit out of New York, they say they gave good reasons that they needed a license, and they were still denied, they say. One of them requested a license for self-defense after a string of robberies in his neighborhood. Another man showed he had participated in safety training courses, but both were still denied.
Now, to understand this case, I have to take you back to another case. Justice Scalia wrote the opinion in D.C. v. Heller. Now, in that case, it's very important to understand. The court established an individual's right to have a gun in their home for self-defense. So the next logical question is, well, what about outside the home, right? Self-defense isn't limited to when I'm at the house. I have the right to self-defense even if I'm outside of the home. So what about the tool to help me defend myself? I have a right to it in my house, but do I have a right to it outside the home? When it comes to having a weapon outside the home, in New York, the law requires that citizens show that they have a great need for a carry and conceal license. This means that they face a special danger to their life. To be technical, special or unique danger to their life. Now, this is a very high standard to overcome. So the question a court's going to answer is whether New York's denial of the petitioner's carry and conceal licenses for self-defense violated their Second Amendment rights. Prediction. I think 3 liberal justices are going to vote to uphold the restriction limiting the Second Amendment to the right to own a firearm in your home. But I think the other 6 justices will likely expand that right to own a gun outside the home, but with a different standard. Not as high as the one that New York has put in place. Maybe something like an undue burden standard, like the one used in abortion cases. For those of you who don't know, the undue burden standard is when a particular law or regulation is so burdensome on someone's constitutional or fundamental rights that the law has to be overturned. And I think that's what you're kind of seeing here, where you can have some standard in issuing these licenses, but this standard of this unique and special danger to your life, I think may just be too high. I think the standard is going to change because you still have to allow states to be able to regulate people with weapons outside the home. But I think the standard is going to be reduced from this special needs standard. And I think they're going to do that in a 6-3 ruling. But we'll see. Now, from the state of New York, we travel to the state of Maine for our next case, Carson v. Makin. Now, here are the facts of this case.
This case arises out of Maine. Maine is sort of classically rural, and that kind of creates the dynamic that leads to the case, which is they divide the state up into these educational districts, but many of the educational districts are so sparsely populated that they actually can't sustain a high school in that jurisdiction. So they might have elementary school, but by the time it gets to high school, they don't have their own high school in the district. So the state law provides essentially state funding to go to a secondary school, either in an adjoining public district or a private school. And the availability of private schools has long been part of the program. You can even go to boarding schools and fancy places like that. But the law has long had an express prohibition on using the funds at a sectarian school. So it is expressly limited to non-sectarian private schools. And in light of the Espinoza and Trinity Lutheran cases, that kind of facial prohibition on using otherwise broadly available aid to go to a sectarian school or a religious school, and that kind of express sort of limitation of public funding to non-sectarian schools seems very vulnerable under the Free Exercise Clause and the logic of the Espinoza and Trinity cases.
Now, to really understand this case, you have to understand a case from last year, June 2020, Espinoza v. Montana Department of Revenue. Now, in this case, you essentially had the exact same facts, where religious schools were barred from receiving public funds because they were religious. The Supreme Court's 5-4 ruling said this.
The Supreme Court said the government cannot deny benefits to religious schools that it's giving to secular private schools unless the government can meet strict scrutiny, which would basically require showing that it would violate the Establishment Clause for the government to give the aid. And here the court saw no violation of the Establishment Clause. I think it's important to put this case together with one from 3 years earlier, Trinity Lutheran versus Comer. There the Supreme Court said it violated free exercise to deny religious schools aid for the surface of playgrounds that secular private schools could receive. But in footnote 3 of that opinion, Chief Justice Roberts said it was just a case about aid to playgrounds. We now see it's not just about aid to playgrounds.
When it chooses to subsidize non-public education, private schools, that it can't discriminate against the schools just because they're religious, unless, of course, there's a compelling interest, which doesn't seem likely in this context.
So with this precedent and the court becoming more conservative, it looks bad for the state of Maine. That brings us to the question presented. Is the state of Maine violating the religious or equal protection clauses of the United States Constitution by prohibiting students who are participating in an otherwise generally available student aid program from choosing to use their aid to attend schools that provide religious or sectarian instruction? Prediction time. I think this is our best bet for another 6-3 Supreme Court decision against the state of Maine. And let's just think about it. Based on how the court both voted in the Espinoza case to give public funds to religious schools, and that's essentially what this case is about, I think a 6-3 split is your best bet. And I think it could even go up to 9-0 if the 3 liberal justices hold to stare decisis. If they don't, then it's 6-3, but I think at minimum, you have a 6-3 against the state of Maine. So we're taking you from now the state of Maine to the state of Texas in the case Ramirez v. Collier. Now, this is a death penalty spiritual advisor case. Here are the parties. John Ramirez is a death row inmate, and Brian Collier is the executive director of the Texas Department of Criminal Justice. So here are the facts.
Ramirez v. Collier, yes. So this is one of a couple of death penalty cases that together raise interesting issues, not just the death penalty, but things like religious freedom and terrorism. And in the Ramirez case, you had a death row inmate who in the death chamber wanted to have his pastor by his side to lay hands on him and say prayers as he died. And he believes that the laying of hands on him and the audible prayers while he is dying will ease his way into the afterlife. The state, blanking on this, I think was it Texas?
Yes.
Texas allows the pastor to be in the death chamber, but I think doesn't allow the pastor to be close enough to touch the death row inmate, and doesn't allow the pastor to say anything while he's in there. So just has to stand quietly by. So the inmate brought a challenge under a statute called RLUIPA. RLUIPA is essentially the Religious Freedom Restoration Act as applied to prisoners. And it has the same standard as the Religious Freedom Restoration Act. Does a state law impose a substantial burden on the exercise of religion? And if it does that state law satisfy strict scrutiny? That is it the least restrictive means of furthering a compelling governmental interest? And Mr. Ramirez argued that prohibiting his pastor from laying hands and voicing prayers during his execution imposed a substantial burden on his exercise of religion. His argument was rejected up the chain until it got to the Supreme Court. The Supreme Court then stayed the execution and granted certiorari.
John Ramirez is 37 years old, and he was convicted of capital murder in 2008 for the murder and robbery of Pablo Castro. Now, Pablo Castro was a convenience store clerk in Corpus Christi, and this murder happened in 2004. Now, court records say that Ramirez stabbed Castro about 29 times during the robbery spree to get drugs and to impress two women that he was with. Now, at the time of his death, it was alleged that Castro only had $1.25 on him. So, what's the question presented here? Now, this is a pretty interesting one. The question presented in this case: does the state's decision to allow Ramirez's pastor to enter the execution chamber, but forbidding him to lay hands on him until he dies, sing prayers, say scriptures, whisper prayers, whisper scriptures, or any audible noise? First, the court's going to ask, does this substantially burden Ramirez's exercise of his religion? If it does the state have a compelling government interest why they can restrict this type of activity within the execution chamber? All right, so prediction time. I have absolutely no idea. I understand that this court is highly protective of religious liberties, but how far does that go? And that's kind of where the court has to kind of slice things out. You know, is laying hands on him too much? Is praying loudly? Is that something that you really should be able to prohibit as a state? Who knows? But this court will let us know. This ruling could be anywhere where it allows the state to continue this practice, or it can overturn it and allow Mr. Ramirez's pastor to do these things. Let me know how you think about the cases. Let me know how you came out. Did you come out like I did, or do you think I'm crazy? Now, with that said, don't forget to click on one of these great videos right here. And my name is Nate the Lawyer, and I'll see you next time. Peace.